Hello and welcome back. It's been at least a couple of weeks or more since we last discussed employment law topics regarding our assigned readings. In today's segment, we're going to be talking about restrictive covenants, invasion of privacy claims, false light invasion of privacy, right to privacy in the Workplace Act, and eavesdropping issues. We're going to start off talking about restrictive covenants. And really, restrictive covenants in this jurisdiction are focused on three types of agreements. One would be a confidentiality agreement. Second type of agreement we'll cover is the non-compete agreement, and then the non-solicitation agreements. Let's talk first about confidentiality. Many employers will require employees to sign a so-called confidentiality agreement. And what those agreements provide is that the employee agrees to keep confidential information that they've acquired because of their employment relationship with the employer or the company. Confidential information would be information that is unavailable outside of that workplace setting. In other words, just because that employee is working, they've acquired information that is not available outside of that employment environment. And that is something that the employer usually chooses to protect. It's confidences, information that is unique, information which may be proprietary in nature. When you hear the term trade secret, the trade secret may consist of a formula, a device, or a compilation of information that is used in a business and is of such a nature that it provides an advantage over competitors who do not have that type of information. And in your assigned readings for this segment, Professor Twomey discusses non-competition agreements and other related restrictions. A non-solicitation agreement would be a prohibition against soliciting or contacting customers or clients with whom the employee had contact during their employment. A non-compete agreement is more general in nature and prohibits overall competition in a given industry or segment. So a non-solicitation restriction is more focused, more narrow, and avoids the employee from contacting and trying to take former customers, clients of that company that they came in contact with and had knowledge and information about because of their employment relationship. Two types of non-compete agreements exist. One relates to the transfer or sale of businesses. We're not going to talk about the non-compete agreements in that context, but we will be focusing on the non-compete agreements within the framework of the employment relationship. And in an employment agreement, for a non-compete restriction to exist, because it's contractual in nature, it can be either oral or written in form. The non-compete agreements for employment, as just mentioned, can be written or oral. The restrictions can be for a specific defined time frame, or no time frame may be defined at all, similar to an at-will employment relationship. And the restriction can be a separate contract or incorporated within another employment-related document, such as a policy manual, or a restrictive stock agreement, or related employment or corporate policies. There's a common law application. As the restrictive covenants are contractually based, common law application is made. Courts decide, and courts make determinations of whether the restrictive covenants are enforceable. Litigation is traditionally two-part based. One, there would be a complaint for breach of contract. That would be where the employer or the former employer files a lawsuit alleging that the restrictive covenant has been breached by the employee or the ex-employee and is seeking damages as a result of that alleged breach. What generally happens in this type of litigation is that along with a breach of contract claim, which is a prerequisite, there's also a temporary restraining order sought. You may have heard the term TRO. That stands for a temporary restraining order, or a preliminary and permanent injunction. That's where the employer or the former employer seeks to restrain until the resolution of the restrictive covenant is decided as to its enforceability, that employee from competing or working in a context that arguably may be in violation of that restrictive covenant. What typically also happens is that if the employee, the former employee, joins another company that is competitive to the former company, that new company will also be sued as a defendant for the interference or the violation that the former employee has allegedly committed. So what typically will occur in this type of litigation is that not only will the former employee be named as a defendant, but their new employer will also be named as a defendant by the former employer in that lawsuit. Most employers will ask employees today whether they have an existing or a past restrictive covenant that may relate to their former employment. In fact, there's an obligation for an employee to make that type of disclosure, especially where the covenant still is existing with respect to some time duration or geographic restrictive scopes, which we'll talk about in just a few minutes. Where the employee does not divulge or keeps from the new employer information that they were governed by an existing restrictive covenant, that new employer probably will fire that employee once they get notice that there's an arguable interest at stake by the former employer seeking to restrain their new employee from working. I should say restrain their former employee at the new place of employment from working and arguably violating the restrictive covenant. Let's look at restrictive covenant agreements with regard to traditional legal analysis. Traditionally, the enforceability of the restrictive covenant is based on three criteria. One, is there a reasonable time restriction? For example, a 1-year restriction may not be unreasonable, whereas a 5-year time restriction may be considered unreasonable. Another criteria would be, is the restriction reasonable in terms of its geographic scope? Many employers will want to restrict their employees from competing within a particular geographic region. Now that region is going to be based on a specific location, and it might be within a 5-mile radius, a 10-mile radius, or something similar that is important to the interest of the employer. Location, location, location. That's a real estate term. Well, it also has application here to restrictive covenant analysis, at least traditionally. If the geographic restrictive scope is reasonable, you have to look at where that region or where that geography is located. If the restrictive covenant applies to a 15-mile radius from where the previous employer was located, it makes a big difference whether the area is within an urban location or whether it is in a rural location. So geography and location does make a very big difference in terms of whether the geographic scope of the restriction is considered reasonable. And the last criteria, which traditionally has been involved in the legal analysis regarding the enforceability of these restrictive covenants, is does the employer or the former employer have a protectable interest really at stake? In other words, is there an interest that the courts should protect and restrain the employee from arguably violating? If the interest is not worth protecting, then the enforceability of that restrictive covenant probably will not be upheld or granted by the court. Let me give you an example. If the employer is trying to restrict the employee's right to compete, and really non-compete agreements are restraint of trade restrictions and are frowned upon by courts, and in some jurisdictions, the legislatures in those locations have even ruled or enacted laws that they're not going to be enforceable. And Professor Twomey certainly indicates in your casebook study that there are some jurisdictions that simply will not honor the non-compete or covenant restrictions, by statute. But courts will look at whether or not there are these three traditional points to consider: the protectable interest, the reasonable restriction on geographic scope, and the reasonable time restrictions. Going back to my earlier example, if the employer is trying to enforce an agreement and to keep the employee from competing, if there is a group of customers that the employer is arguing represents a protectable interest, if those customers can be found, for example, by looking on the internet, and their identities are known and well known, and anyone has access to those alleged protected customers, then really there may not be a protectable interest that the courts would be willing to advance. We'll talk about that in just a moment. Courts have traditionally examined whether the employer has a legitimate employment business interest to protect in order for the covenant to be enforced. The employer must show, at least traditionally, that the employee acquired confidential information through their employment was attempted to be used for confidential and proprietary information in violation of the covenant for that employee's own purpose or to advance the purpose of another. Now, that other may be a new employer, for example. So what exactly is a protectable interest? Well, courts in Illinois have examined that question in detail over the years, and courts have concluded over time that customer relationships that are sought to be protected must be of almost a near permanent nature. In other words, the employee would not have had access to that particular customer but for his or her employment status with the employer. So given my earlier example, if that customer is readily available and can be found by access on the internet, then certainly there's not a near permanent nature in that customer relationship with the employer that courts are probably willing to advance or protect. Let's talk about a Supreme Court decision in Illinois that took place in 2011. And this Supreme Court decision is the law in our jurisdiction today. And it really changed the focus of how these restrictive covenants would be considered as to their enforceability. Let's go through this case. It's the Reliable Fire Equipment Company versus Arredondo case. In that case, the Illinois Supreme Court held that the enforceability of employees' covenant not to compete should be judged by the three-pronged test of reasonableness, of which the employer's legitimate business interest continues to be a part, and which looks to the totality of all of the circumstances rather than focusing on named specific factors. In other words, not just to look at the reasonableness of the time restriction. Is 1 year reasonable, or is 5 years reasonable, or is 6 years or 6 months reasonable? Or is the geographic location reasonable in terms of scope? But to examine the restrictive covenant from the perspective of a so-called totality of all of the circumstances. Let's look at the facts in this case. Reliable sells, installs, and services portable fire extinguishers and a variety of fire alarm systems. In November of 1998, Reliable hired Arredondo. Approximately 1 week later, he signed his non-compete agreement. He promised not to compete with Reliable during his employment and for 1 year after termination from employment in Illinois, Indiana, or Wisconsin. So there you have a restrictive covenant that relates to a 1 year time frame and a geographic scope that covers 3 states. He further agreed not to solicit a sales or referrals from Reliable customers. So there's a non-solicitation aspect to this restrictive covenant as well. In 2004, Reliable was concerned that Arredondo was planning to compete with Reliable. Reliable questioned Arredondo whether he was going to start his own business. He denied any such interest. However, on September 1st of 2004, he resigned from Reliable, and Reliable suspected that he was involved in an endeavor which violated their restrictive covenant rights based on the contract that was entered into years earlier. Reliable filed a multi-count lawsuit claiming that Arredondo had breached their contract for the restrictive covenants. The circuit court, which we know is the trial court in our jurisdiction, held that the restrictive covenants were unenforceable. The trial court concluded that Reliable failed to prove the existence of a legitimate business interest, that's that protectable interest factor, to justify enforcement of the covenants. The case was appealed to the appellate court, whereby the appellate court concluded Reliable did not have a legitimate business interest that warranted or justified enforcement of the restrictive covenants. The case was appealed to the Supreme Court. The Supreme Court reversed the appellate court's decision and remanded the case to the lower court for further proceedings. Let's look at the court's decision in more detail. And again, this is to give you more of a general understanding regarding the non-compete, non-solicitation, the confidentiality type of restrictions that form the so-called restrictive covenants, at least in the jurisdiction here within Illinois. The Illinois Supreme Court ruled that restrictive covenants must be analyzed with reference to the totality of the circumstances. And we've heard that term before too, in other contexts, to determine if the employer has a protectable interest as opposed to utilizing the typical rigid version of a legitimate business interest test. The Supreme Court emphasized that each case must be determined on its own particular facts. Reasonableness is gauged not just by some, but all of the circumstances. The same identical contract, for example, and restraint may be reasonable and valid under one set of circumstances and unreasonable and invalid under another set of circumstances. Well, what does the Supreme Court mean by that? Well, perhaps there's different businesses, there's different industries by which these standards and the totality of circumstances can be evaluated. One industry may be different from another industry, and hence the competitive issues involved may vary. There may be an industry where there are thousands of competitors, and there may be an industry where there are only just a few. So the competitive nature of the situation, the context may differ. And the Supreme Court in Illinois says you've got to look at the whole big picture, so to speak. You can't just look at, number one, is there a time restriction that's reasonable? Two, is there a geographic scope restriction that's reasonable? And three, is there a protectable interest at stake? Now, the Supreme Court said you don't rule those out, but they're not standalone factors that are going to determine the enforceability of these restrictive covenants. You've got to look at the big picture view and the so-called totality of the circumstances. So in sum, the legitimate interest or business test still is viable. However, to be employed as a part of the third prong rule of reason to determine the enforceability of a restrictive covenant not to compete, the court will focus on the bigger picture. A test which focuses on determining a near permanent customer relationship and the employee's acquisition of confidential information through his employment is no longer the sole criteria. Instead, a legitimate business interest exists based on the totality of the facts and the circumstances of the individual case. Let's look at this in a little bit more detail. Factors to be considered in this analysis include, but are not limited to, obviously the near permanence of the customer relationship and the employee's acquisition of confidential information through his employment and the time and place restrictions involved. No factor carries any more weight than any other, but rather its importance will depend upon the specific facts and circumstances of the individual case. So when examining the non-compete restrictive covenant context under Illinois law, the focus is really an individualized examination, looking at not just certain sets of circumstances, but the bigger picture view as to whether or not the restrictive covenant will be enforced or not. And that's a question that may be examined in a lot of detail through the courts. Now, there's a case that I wanted to bring to your attention here in our jurisdiction, which really has tremendous application in terms of some practical aspects, some real-life factors. And the case involves an appellate court decision that took place about 18 months after the Illinois Supreme Court decision of reliable fire equipment in Arredondo. The case involved a person named Fifield. In fact, there's a lawsuit called Fifield versus Premier Dealer Services, Inc. Fifield was employed by Great American Insurance Company. He was assigned to work exclusively for Premier Dealer Services, which was a subsidiary of Great American. He signed a non-solicitation and a non-competition agreement as part of his employment contract with the employer. He resigned 3 months after he started to work. The appellate court ruled, and this is the holding of that case, that a minimum of 2 years continued employment is necessary to establish adequate consideration for a restrictive covenant. Hence, the non-solicitation, non-competition provisions of the employment contract were ruled invalid and unenforceable due to a lack of consideration. So, what does all this mean? In this particular jurisdiction where there's the appellate court application, an individual employee, unless they have worked for 2 years for that company, is not going to be bound by the restrictive covenant for lack of consideration. Now, that's an appellate court's decision. Not all courts have followed that decision, particularly the federal courts in this jurisdiction, when they've been asked to examine these particular questions as part of a lawsuit where there's also federal jurisdiction of other claims. The Fifield case really set the area here in Northern Illinois on edge a few years ago when this decision was made by the appellate court, I should say, because the enforceability of these contracts, and that's what they are, the contracts, depended upon adequate consideration. According to this appellate court, unless the employee worked continuously for 2 years, the employment restrictive covenant was unenforceable. So, if the employee-employer relationship lasted a number of years, then of course, based on the consideration of that ongoing relationship, that long-lasting relationship, there would be adequate consideration to support the contract. Now, I mentioned earlier that there are some states that, by legislative enactments, have held or have legislatively determined that these restrictive covenants are unenforceable. So they're against the law by way of statute. Illinois is not one of those states. However, in January of 2017, January 1 of 2017, the Illinois Freedom to Work Act became effective. And some of you may recall that early on in this course, I asked you to do some research and to post on your information boards and to share with each other whether there's new laws that are in effect for this particular year based on legislative enactments. And one of the legislative enactments relates to non-compete agreements. The Illinois Freedom to Work Act applies to low-wage employees. A low-wage employee means an employee who earns the greater of 1, the hourly rate equal to the minimum wage required by the applicable federal, state, or local minimum wage law, or 2, $13 an hour. And by this legislative enactment, restrictive covenants relating to any work for another employer for a specific period of time, that's the time duration restriction, or any work for a specific geographic area, that's the geographic restriction, or work for another employer that is similar to such low-wage employees' work, that's that protectable interest involved, and that competitive advantage that's being sought is going to be examined. So, by way of statute, there's an exception to non-compete agreements for low-wage employees in Illinois. They're unenforceable by law for these particular individuals that fall within this category. Otherwise, we've got the common law application where decisions are made on a case-by-case basis using the legal criteria that we've been discussing. That's really a very general overview of this particular area of law. Professor Twomey in your case book discusses non-compete agreements, non-solicitation agreements, and please make sure you've got a good comprehensive understanding as to what's covered in the text as well. Let's talk next about invasion of privacy. There's a lot of information in your textbook about invasion of privacy. There's discussion about testing, eavesdropping, electronic surveillance. There's a lot of information in your textbook, all that relates to invasion of privacy concerns through the legislature and also through the courts. We're not going to be able to, in this segment, talk about all of which is covered, but I do want to highlight several of the areas that I think we should have a better understanding of and more focus upon. The tort of invasion of privacy, it's a tort, not a contract, but it's a tort, is one of the newest, most developing torts within both common law and statutory context, because there's statutory enactments that relates to invasion of privacy concerns. Under Illinois law, the right to privacy includes 4 recognized torts and remedial provisions, which include 1, the intrusion upon seclusion of another. That's a category of invasion of privacy that's recognized under Illinois law. 2, the appropriation of name or likeness of another. That's an invasion of privacy aspect. 3, publicity given to one's private life. That's an aspect of an invasion of privacy. And 4, publicity placing a person in a false light. When you hear the term false light, it involves an invasion of privacy claim, that a person is being placed in a false or negative light publicly that impairs their good name and reputation. Note that an invasion of privacy false light tort is not defamation. Very similar, but it is very different. And I've cited a case that really focuses on a general discussion regarding these 4 recognized categories of invasion of privacy torts here in Illinois. It's the case of Benitez versus KFC National Management Company. The case site, if you want to look it up, is 305 Illinois Appellate 3rd District, or 3D 1027. It's a 2nd District Appellate Court case decided back in 1999. But it does give a lot of explanation as to these areas within the invasion of privacy context under Illinois law. The restatement of torts, which is a compilation of various tort claims that have been codified, defines the invasion of privacy tort as one who gives publicity to a matter concerning the private life of another, is subject to liability to the other for invasion of his privacy if the matter is of a kind that 1, would be highly offensive to a reasonable person, and 2, is not of a legitimate concern to the public. In other words, the public would have no reason to have any concern or awareness of the subject. For false light invasion of privacy, the restatement 2nd of torts defines a tort as one who gives publicity to a matter concerning another that places the other before the public in a false light and is subject to liability to the other for invasion of privacy if 1, the false light in which the other is placed would be highly offensive to a reasonable person, and 2, the actor had knowledge of or acted in reckless disregard as to the falsity of the publicized manner and the false light the other would be placed within. To state a cause of action for false light invasion of privacy, a plaintiff must allege 1, that the plaintiff was placed in the false light before the public as a result of the defendant's actions. 2, the false light in which the plaintiff was placed would be highly offensive to a reasonable person. And 3, the defendant acted with actual malice. That is, with knowledge that the statements were false or with reckless disregard for whether the statements were true or false. And again, I've cited a case. Should any of you want to look at this case, it will focus in more detail and give you much more background information. It's the Tobias versus Oak Park and River Forest High School District case. It's a very recent case decided in 2016, and the case site is 57 Northeast Reporter, the 3rd edition, 551 is the site, and a lot of information is contained on 574, page 574 of that case. It's a 1st District Appellate Court case, which is clearly within our jurisdiction. With regard to actions for false light, actual malice is also an aspect that needs to be considered. We've talked about malice in the context of defamation claims. Actual malice is defined as knowledge that the statements made by a defendant were false or that such statements were made with reckless disregard as to their truth or falsity. To prove false light invasion of privacy, a plaintiff must show that something false was stated. Well, that's similar to a defamation claim, but there has to be some falsity involved, which places the person in a false or negative light. Suing for strong criticism, for example, that's neither true nor false, but merely opinion, is not actionable. And that is a ruling from a case that was decided in federal court in 2004. And again, these case sites are there if any of you want to look at them in more detail for some of your own research. Let's talk about public disclosure of private facts. That's another aspect of invasion of privacy which is recognized under Illinois law. Unlike defamation law, which requires only a communication to a third person, a private facts invasion of privacy claim requires that the matter be communicated to the public at large or to so many people that the matter must be regarded as one of general knowledge. For example, a broadcast, a publication in a newspaper or magazine, no matter how great or extensive the circulation, will generally establish sufficient publicity. But courts have also found the requisite publicity element in situations whereby disclosures to even co-workers may constitute the requisite public occurrence. And there's a case involving Motorola that was decided back in 1990 by the appellate court. Miller versus Motorola, Inc., 560 N.E.2D, second edition, the Northeastern Reporter at 900. We'll give you some information about that, that aspect if you're interested in looking at it in more detail. Let's talk about a state legislative act called the Right of Publicity Act. This is a privacy law that originated not by common law or through the courts, but through the legislature. In Illinois, the Right of Publicity Act went into effect January 1 of 1999. Under that act, the right to control and choose whether and how to use an individual's identity for commercial purposes is recognized as each individual's right of publicity. In recognition of an individual's right of publicity, the act provides that a person may not use an individual's identity for commercial purposes during the individual's lifetime without having obtained previous written consent. As part of this past week's assigned readings, I have attached a copy of the Right of Publicity Act. So I would encourage you to look at that act, examine it in some detail, and if anyone's identity is going to be used for a commercial purpose, consent must be obtained. Consent must be obtained. And the best example of consent would be some type of writing, a contract, a disclosure that certainly is evidence of the individual's understanding that their likeness will be used for a commercial purpose. I want to also talk about another act that has tremendous effect here in Illinois, and it's called the Right to Privacy in the Workplace Act. That act was in effect in 1992. The Illinois General Assembly, the legislature, passed the Right to Privacy Act. The purpose of the act is to prevent employers from requesting information about whether an employee previously filed claims for benefits under the Workers' Compensation Act or the Workers' Occupational Disease Act. We've talked about invasion of privacy issues and rights of privacy with respect to the Americans with Disabilities Act. Well, in Illinois in 1992, the legislature passed this law that prohibits employers from inquiring about whether applicants or employees at one time previously filed claims for workers' compensation or claims under the Workers' Occupational Disease Act. And again, the purpose was to restrict information that the employer would have no reason to obtain otherwise, and it really would be an expectation of privacy that the applicant or the employee would have with respect to previous injuries that have occurred at work for which there might have been a claim about. Now, that act has been amended from time to time. Let's talk about an act, the Right to Privacy in the Workplace Act, that was amended in 2013. That act, amended in 2013, was designed to prevent employers from requesting employees and applicants social media passwords on networking websites, and to further prevent employers from requiring employees or applicants to provide passwords and other information that would allow employers to gain access to such information. So the legislature decided in 2013 to expand the Right to Privacy in the Workplace Act by making this amendment that focused on social media and access to passwords or networking websites. Effective January 1 of 2017, the Illinois legislature amended again the Right to Privacy in the Workplace Act. And I want to focus here on the 6 areas in which really relate to this amendment that I believe are important and that we should have some understanding about. Employers are prohibited from 1. Asking, requiring, or coercing employees or applicants to provide passwords or other related account information for accessing their personal online accounts. 2. Employers are prohibited from demanding access to employees and applicants' personal online accounts. There's a prohibition against asking, requiring, or coercing employees and applicants to authenticate or access their personal online accounts in an employer's presence. There's a prohibition against requiring or coercing employees and applicants to invite employers to join groups affiliated with their personal online accounts. There's a prohibition requiring or coercing employees and applicants to join the employer's online accounts or add employers or employment agencies to contact lists for their personal online accounts. The legislature has also recognized that the potential for retaliation exists and has built in an anti-retaliation component within this law, whereby employers are prohibited from retaliating against an employee or an applicant for refusing any of the above activities. Many of you at the outset of this course, when you were asked to research and identify whether new laws in Illinois exist, certainly found this to be a new law and commented on it. So I said at the time that we would focus on some of these new laws as time went on, and certainly this is the area under invasion of privacy and rights of privacy that we need to understand how the legislature, besides the courts, look at these types of issues. Let's again look at the amendment in 2017 to the Right to Privacy in Workplace Act. Employees who feel that there's been a violation, or applicants who believe that their rights may have been violated under this act, may file a complaint with the U.S. Department of Labor or commence an action in state circuit court to enforce the provisions of the act. Awards, the Illinois Department of Labor as well, the awards may include actual damages and cost and attorney's fees and up to a $200 per violation occurrence. Employers may also be found guilty of a petty criminal defense, should be criminal offense. One thing that I believe is important for our consideration is what's the time limitation that governs common law rights to invasion of privacy claims. We've had discussions previously about statutes of limitations. We've said, for example, that under the Illinois Human Rights Act, you have to file a charge within 180 days of the alleged discriminatory occurrence. Under federal law in our jurisdiction, there's a 300-day limitation period. For cases involving breach of contract, oral contracts, implied contracts are governed by a 5-year limitation period. Written contracts are governed by a 10-year statute of limitation period. Many torts, which we'll talk about yet in more detail in the couple of weeks remaining in our course, are subject to a 2-year statute of limitation. When it comes to invasion of privacy torts, similar to defamation torts in Illinois, a 1-year period of limitation applies. A 1-year statute of limitation applies to invasion of privacy torts, those 4 tort areas that we've earlier discussed. Compensatory damages and punitive damages can be sought. For statutory invasion of privacy claims, which we've identified through the legislature's actions, may allow for attorney's fees and cost to be recoverable by statute. Attorney's fees and cost are not recoverable for common law claims. I want to also bring your attention to another invasion of privacy subject, and that's referred to as eavesdropping. There's some information in your text about eavesdropping issues. Professor Twomey has identified in your casebook, in your textbook, examples of eavesdropping and cases actually where there's been intentional interception of wire, oral, or electronic communications. Both state and federal laws generally prohibit intentional interception of wire, oral, or electronic communications. A federal statute, 18 U.S.C. 2511, Section 1, allows interception and recording where the recorder is a party to the communication or one of the parties to the communication has consented to the interception, as long as the interception is not intended for committing any criminal or tortious act. Under the Illinois Eavesdropping Act, it is generally a crime to record a conversation without the consent of all parties involved. I am not a criminal defense attorney. I practice employment law exclusively, but individuals in workplace settings must be very cognizant or understanding that if they record conversations without the consent of all the parties involved, there may be some criminal aspect to their conduct. The Illinois Eavesdropping Act has been a focus of both the courts and the legislature recently. If any of you have an interest in looking at the Eavesdropping Act, please do so. It's found at 720 ILCS 5/14-2A of the Illinois compiled statutes. But I wanted to make note that it could be illegal in many situations for an individual to record conversations without the other party's consent. We're also going to talk about the case of O'Connor versus Ortega. And that case is in your textbook. I'm turning to that now on page 637. It's a case that really is in 2 parts. The part that you've been asked to study first is found on page 637, and it's the United States Supreme Court decision in 1987. And before we examine this case in detail, and it's a very important case for our understanding regarding privacy interest and privacy rights, I want to focus on a couple of concepts here that you need to keep in mind. One concept is a so-called expectation of privacy. Let me repeat that. Expectation of privacy. Ask yourselves, do you have an expectation of privacy? And if you have, is that expectation reasonable? The reasonability of that expectation is going to depend upon the context, the space and the location and the setting. For example, if you're out in the street walking, that's a public area, the street, you come in contact with any member of the public, you would have no expectation of privacy in such context. On the other hand, if you're inside your house where no one is allowed in except for your guest that you've invited, you would have a high level of privacy expectation, much different from being out in the public. So ask yourselves, what area, what confine, what space would you have a reasonable expectation relating to your privacy interest? Next concept I want you to focus on is the distinction between private and public employment. Big difference. With regard to public employment, when I say public employment, employment that relates to governmental employment, where the employee is paid through taxpayer dollars. Whenever there is a taxpayer dollar nexus to that employment relationship, there may be a public employment aspect, and when there is the United States Constitution that will be involved. Private employment situations will not ordinarily involve the United States Constitution. The Fourth Amendment, which prohibits unreasonable searches and seizures, is a constitutional protection. And any public employee, an employee who works for the government and is paid through taxpayer-supported dollars, is going to have constitutional protection. So ask yourselves, first, what is the reasonable expectation of privacy? And second, is there a public or a private employment situation at stake? Big difference in terms of the application of law and the protections which courts will afford. So, having said that, let's look at the O'Connor versus Ortega case. And before we talk about the more detailed facts, I want you to look at the years in which this case actually was litigated. When did the situation occur? 1981. When did the United States Supreme Court render its decision? 1987. If you look at the second Ortega case, after litigation continued, we have a decision after it went to the Ninth Circuit Court of Appeals in 1998. So what does that suggest? 17 years of litigation in our judicial system. This case found itself within. What does that say about our litigation system in the United States? Well, it's thorough, it's detailed, and there's always lots of avenues and lots of procedural and substantive rights and rights of due process, but it can be a very lengthy, time-consuming endeavor. Might be an argument for mediation, might be an argument in favor of arbitration. But I wanted to point out the length of time that this particular case was actually subject to the court system, to just highlight the litigation aspect of our judiciary. Let's look at the facts. Ortega, a physician and psychiatrist, was an employee of a state hospital. Hospital officials became concerned about possible improprieties. Allegations of sexual harassment were made against him by female hospital employees, and also there was an inappropriate disciplinary action taken which raised some interest. While Ortega was on administrative leave, there was an investigation of the charges. Hospital officials allegedly, in order to inventory and secure state property, searched his office and seized personal items from his desk and his file cabinets. that later were used in administrative proceedings resulting in Dr. Ortega's discharge. No formal inventory of the property in the office was ever made, and all of the other papers in the office were placed into boxes for storage. Ortega filed a lawsuit against the hospital alleging that the search of his office violated the Fourth Amendment. The Supreme Court ruled that searches and seizures by government employers or supervisors of private property of their employees are subject to Fourth Amendment protections and restraints. An expectation of privacy in one's place of work is based upon societal expectations that have deep roots in the history of the amendment. And that's found within the court's opinion. However, the operational realities of the workplace may make some public employees' expectation of privacy unreasonable. Dr. Ortega may have had a reasonable expectation of privacy, at least in his desk and file cabinets. In determining appropriate standards for a search conducted by a public employer in areas which the employee had a reasonable expectation of privacy, what is a reasonable search depends upon the context within which the search takes place and requires balancing, so the Supreme Court says, of the employee's legitimate expectation of privacy against the government's need for supervision, control, and efficient operation of the workplace. Requiring an employer to obtain a warrant whenever the employer wishes to enter an employee's office, desk, or file cabinets for a work-related purpose would seriously disrupt the routine conduct of a business and would be unreasonable. The Supreme Court commented that requiring a probable cause standard for searches of the type at issue would impose intolerable burdens on public employers. Their intrusions on the constitutionality protected privacy interest of the government employees for non-investigatory work-related purposes, as well as for investigations of work-related conduct, should be judged by standards of reasonableness under all the circumstances. Under this standard, both the inception and scope of the intrusion must be reasonable. Justice Scalia, who authored the decision of the Supreme Court case of O'Connor versus Ortega, concluded that the offices of government employees and the drawers and files within those offices are covered by Fourth Amendment protections. The case was remanded to determine whether the search was reasonable under the circumstances with those standards imposed. So as you read further then on page 639 of your textbook, there was a trial that took place that resulted in an award of $436,000 in compensatory and punitive damages in favor of Dr. Ortega for the alleged intrusion into his privacy. And the case went to the appellate court, the Ninth Circuit Court of Appeals, and the Circuit Court of Appeals affirmed the trial court's decision regarding damages for the violation of Dr. Ortega's privacy rights. So, we have concluded our discussion and focus regarding restrictive covenants, invasion of privacy torts, various statutory coverages that relate to privacy in the workplace. We focused our discussion on Privacy in the Workplace Act, all of the amendments recently that relate to even social media issues, and of course I wanted to bring up the eavesdropping aspect too for your attention and your consideration. Thank you very much.